Welcome back to the Takeout. Supreme Court Thursday issued a decision that will allow the abortion pill Mifepristone to continue being sent through the mail, at least for now. It blocks a lower court order that would have prevented Mifepristone from being prescribed via telehealth and sent through the mail, including to states with total abortion bans. CBS News legal contributor and Loyola Law School professor Jessica Levinson joins me now. Jessica, this is a complicated one. Many are, but this one is acutely complicated. Is what the Supreme Court said yesterday the final word?
This part is not complicated. This is not the final word. This was a rocket docket or shadow docket decision, as you know. And what the court really said is, while this case plays out, this is a suit brought by Louisiana. As you said, the Fifth Circuit had implemented a stay. While this case plays out, people can still get Mifepristone through a telehealth appointment in the mail. I think that there is every likelihood that the merits of the case, not whether the drug companies are entitled to emergency relief, but the merits of the case make their way back to the Supreme Court.
And what are the merits of the case? Is it a challenge to an FDA alteration of an existing policy that occurred during, if I remember correctly, COVID 2021?
That's exactly right. So there was a change to the FDA rules. Previously, you needed an in-person appointment to give Mifepristone. During COVID, obviously, it was much harder for people to have in-person appointments. And so the rule was temporarily changed. It was, I believe, in 2023, right after the Dobbs decision that overturned Roe v. Wade, that the FDA said that that change in the regulation could actually become permanent. Louisiana then brought a suit, and part of what they're arguing is that it undermines their ability to ban abortion. Because if the FDA says, well, you can get this abortion pill in the mail by telehealth, then it undermines Louisiana's essentially outright ban on abortions.
And therefore undercuts their state rights to carry out state policy as their legislature has deemed it proper.
You never need to come to my constitutional law class. That's exactly right, and therefore undermines their states' rights. In addition, as you know, there's a separate but related argument that the FDA basically rushed this decision, that they didn't go about it the right way. And the Trump administration had actually taken kind of a, I don't want to say middle approach, but the Trump administration had said to the courts, let's wait while there's a study into the safety of Mifepristone, into how it was approved to be used via telehealth and mail. And so the Trump administration was not arguing for a ban on telehealth and obtaining Mifepristone by mail right now. They basically said, let's wait a minute while that study is confirmed. But you're exactly right. Louisiana is arguing this is our right as a sovereign. It's a health, safety, and welfare rule, and FDA don't undermine that.
Very quickly, remind our audience, Jessica, of how widely used Mifepristone is.
So it is widely used. It's one of the two pills that's used in abortions in this country. I believe that about 2/3, it might be about 65%, as of the last good data I saw, of abortions in this country are achieved by using by a medication abortion. And I think upwards of 90% of those 2/3 are achieved by using Mifepristone in addition to one other drug.
So if you're a woman in that category, Jessica, what should you be thinking in the next year or so?
So obviously looking at this case carefully, because one of the really interesting things, I know this is in the weeds, but I know that you like legal weeds as well, is the question as to whether or not, if the Fifth Circuit says the FDA went about this the wrong way, why that would apply in the entire nation. Because as you know, and we talked about, the Supreme Court said no nationwide injunctions. That's because this case, what we were just talking about, is partly brought under the Administrative Procedures Act. That would allow a court to vacate the rule with respect to the entire country.
Jessica Levinson, great stuff as always. Thank you very much.